Bruins at a meeting prior to my representation. You asked for any documentation of misrepresentations made at the time of sale to homeowners. And so the only three that I've looked at in the depositions, and I'm not litigation counsel for these folks, but I did just pull up the first three and search for testimony under oath of misrepresentations along the lines you had requested at the real estate subcommittee. And you might want to make note of this if you have a pen in your hand as to the Funk deposition. The representations are at page 349, 17-23, and 351, 16-25. In the Stocco deposition, page 50 or 56, whatever you have there, you only have one page, lines 3 to 7. Higgins, page 12, 15 to 21. But what I'd like to do today is divert a little bit from my planned presentation and focus, if I could, on your staff report. That portion of the report on pages 4 and 5 that are in bold for emphasis, and the comments made by Mr. Zuquette at the heart of his testimony today. And both of those emphasize the position of the San Diego City Attorney with respect to the AARP. At your real estate subcommittee meeting, my point was you ought to slow down, take time, and evaluate some of these issues on which my clients contend there have been some significant misrepresentations, so that you can determine for yourselves whether in fact that is correct. And you ought to do that. And Mr. Zuquette's comments and your staff's bolding highlight why you ought to do that. And my recommendation would be that you defer a decision on this matter until such time as the trial in Judge Nevitt's courtroom over the agreement affecting real property and who has rights and what those rights are. And the concern that you ought to have with respect to the applicant's presentation today and your staff report is both of their reliance on Mr. Aguirre's opinion of his office, that they suggest you should rely on rather than waiting for a determination by the judge. And what they quote is the city attorney's opinion that the homeowners who now own property on the parcel that is restricted by the AARP have no rights to assert that AARP as it relates to your decision. Now, the city attorney's opinion is premised and quotes only from the loan agreement. But the AARP is a separate document. And the AARP can be assigned, and it is binding on the successors and assigns from the original owner. When the AARP was entered into with the agency, there were only two parties, the agency and the owners. But the owners have now assigned some of their interest to others. And the AARP recognizes their ability to do that. And the AARP also states, without any equivocation, that the covenants in the agreement run with the land. Now, citing a different document, the city attorney says, but this proves that the agreement is only between the borrower and the agency. And then taking that very language that's in the city attorney's opinion, the city attorney filed a brief to Judge Nevitt in support of a motion to strike the complaint, making the exact same argument they've made to your staff, which your staff has accepted, and which your staff has recommended you accept, stating that the position of my clients is false, using the analysis I have just described for you, taken from the city attorney's opinion. That opinion is dropped right into the motion to strike, and your staff today draws the language the city attorney's office used in its motion to strike and reprints it at page 5 in bold of your agreement, of your memo today. And a report dated approximately a week ago. But on August 17th, 2 months ago, Judge Nevitt rejected that analysis. Your memo today doesn't tell you that the city attorney's analysis was rejected by Judge Nevitt, in which Judge Nevitt rules that it does not appear from the face of the complaint or from any judicially noticed matters that the allegations in paragraph 21 of the complaint are, quote, false matter, end quote. And yet the city attorney has opined it's false matter Your staff has picked that right out of the brief that was rejected by Judge Nevitt and presented it to you without communicating to you that the court has heretofore rejected that argument. Now, that doesn't mean that at a trial of this matter there might be some different ruling. But it would also suggest to you that at this point in time, the San Diego Superior Court has not accepted that argument. It doesn't have the confidence in that the staff has in that. And your staff has not accurately reported to you what's going on. And that's the position I took 2 weeks ago, is that the truly significant determinations individuals who sit on these boards and commissions will make are the times when they ask the staff to set aside and they step in. Because time and time again, in these chambers and in that room over there and throughout this building, and we all know it, we have made some significant mistakes to the detriment of the city because we've relied on staff or we've abdicated our responsibilities to exercise our fiduciary duties. If I were in your shoes today, reviewing a staff report that excerpts from a court pleading that's been rejected by a judge, yet is advanced to you as fact and an opinion you should rely on, I would have serious concern. I would continue this matter. I would send it back for evaluation, and I would reevaluate whether or not you can trust any of the other issues on which you've been briefed by your staff, and something that a lot of people in this community believe is a very important issue. Thank you very much.
Thank you, Charlie. Would you just hold it for 1 second?